First, I want to say thank you to Stephen for really putting this together. Since I could talk for hours and hours, and none of us want that at this point, I'm going to be doing this talk in the style of a Seattle Ignite talk, which are normally about 5 minutes with 15 seconds per slide. I was told I have 15, so I'm only going to take 10, and we're going to go through 40 slides. There is a lot of material that I also added, but we're going to cruise through some stuff. Also, I wanted to point out that although I'm using PowerPoint, this was put together with OpenOffice and is available online both with SlideShare and through Google Docs. So it's really a cross-platform, diverse presentation. For a little bit of background about me, I graduated from the iSchool here at University of Washington about 4 years ago with a degree in informatics that focused on the intersection of human rights and intellectual property. So it's where does freedom of speech run into the First Amendment? Where do we have problems with patents and access to essential medicine? Where does privacy fit into data mining and data portability? These are the ways to get a hold of me, and these are the ways that you can find out more information about what's going on there. Currently, we're living in an infringement nation, somewhere where everything that we do, whether it's forwarding an email, writing things down, copying things from others, happens to be infringement. When copyright was put together originally, it was meant to be, well, 14 years in the US. This is an odd slide because that's the statute of, or supposed to represent the statute of Anne, which was 21 years. But it was for a short, limited period of time. Since then, it has grown exponentially. To this day, we're looking at a life plus 70 years. This was not the limited monopoly that it was originally meant to bring forward or meant to be embodied by our own Constitution. Why does this happen? Apparently somebody has a birthday, or a bunch of individuals who happen to be dead have birthdays. And we see a rewriting of the law, retroactively extending copyright. Along with that retroactive extension of copyright, we also see fundamental changes in the way that copyright is put together. In 1976, we moved from an opt-in, somewhere where you say, I want this copyrighted because I used the copyright bargain to create it, to an opt-out. But they didn't give you a way to opt out. There is a solution to that, though, which is Creative Commons. I had the honor of working there this last summer on different licenses, and I'd like to explain in the next 4 minutes how you can also use those licenses to contribute to the commons. Creative Commons is really in the middle of the copyright space. Public domain says you can do anything with it, go jump off a cliff, use it in any way you want. Copyright is all rights reserved. It's a big stop sign that says stop now, don't go any further. Creative Commons says there's some rights, and those are embedded in 3 different pieces that they put forward. They have a human readable deed, and I honestly wish that all contracts had this. This deed goes forward and shows you that you can share or remix as long as you give attribution. Behind that deed is pages of legal code, and this is the stuff that we all love to read at night to help us get to sleep. But it goes over each individual piece of that contract and explains it in detail. And then they ported it to over 46 different jurisdictions at this point. That was the US one. And it also has invisible, you wouldn't see this on a web page because it's in the background, metadata that lets search engines, that lets other computers know how you can use that. It tells them so they can automate processes of using your work. Now with Creative Commons licenses, there are 4 individual aspects to those license terms. There's by, no derivative, share alike, non-commercial. I'm going to explain each of those a little bit more slowly. The by license, every single Creative Commons license has this by aspect. By says, give me attribution. I created it. Give me a link back, put my name in your book, follow the rules that I put forward for attributing it. If you're going to use it, you must follow the condition of by. And this is what almost everyone wants, is at least credit for the work that they put forward, so they can then find them and work with them on other things. The second aspect that's put forward is non-commercial. Now, non-commercial is a little bit of a fuzzy term, but there are clearly areas where you're selling individual things for direct monetary benefit that are on the not allowed, and there are areas where you're just sharing it and not making any commercial advantage. The next is the share alike, and I'm fortunate to have followed some software people, but this is the provision, the viral provision that says if you're going to create a derivative work or you're going to do anything with this, you must use the exact same license. The non-derivative is really exclusive to Creative Commons licenses. This basically says that you can do what you want as long as you don't change it or alter it in any way, shape, or form. Now, it's also important to point out that none of these licenses affect fair use. Between those 4 aspects, you get 6 main Creative Commons licenses. You mix and match these together, and they each come with that custom code, custom deed to explain to people. Now you're asking, well, how do I license my work? You go to the Creative Commons website and you look for that logo in the upper right-hand corner, and you click on it. It will take you to a very easy screen that asks you 4 or 5 different questions. Those questions, as shown here on the left-hand side, then automatically print out all of the earlier pieces of the license that we saw. In fact, it even adds in the information about you as an author, how you want to be attributed in a micro format or RDFA format. Now, for those individuals who don't really want a license and they want to jump off the deep end, they also have CC0, which was just released these last few weeks. It's a public domain dedication or waiver if you're doing scientific information, or if you're an activist like me that really doesn't care if it's reused and wants it to be reused, that's another option. The next thing I always get asked is, are these licenses enforceable? Fortunately, we had an amazing court case opinion came out this last year, Jacobsen v. Katzer. There's a copy of it in your materials, but the basic answer is yes, and you can get copyright type damages, so you can get injunctions. You can possibly even get statutory damages. The next question people ask me is, how do you make money? Magnitude does that with small artists by making things available to share and then allowing it to be redistributed and renegotiate for large commercial rights. 9 Inch Nails, on the other hand, has left their label, and they put everything up on their website for free, have individuals opt in, and then also sell through traditional markets. This has been extremely successful for them. With Ghosts, Volume 1 through 4, they made $1.6 million in their first week and were the #1 selling downloaded song. So there are business models that work behind these, and that's everything you need to know to be able to go home, use Creative Commons licenses. The second area that I'm going to talk about is the activist side of the free culture movement and the things that we can really do to be involved, whether it's legally or individually, on these topics. Some people think that this really started with Lessig's book, Free Culture, but this goes back much farther than that. It's a wonderful book and it outlines a lot of the reasons why we need a free culture movement, but there have been scholars who've been talking about this issue for a long time. Some of them even try to target this back onto the French Revolution. Although I'm not really interested in the historical aspect of it, I'm more interested in what you and I can do. This individual is one of the 2 people, Karl Malmuth, that I really see as one of my heroes in the free culture movement. He's standing there with a stack of all of the statutes in the state of California. California claims that those are copyrighted. They license the rights to it. He's scanned them, put them up online, and said, hey, sue me. These are in the public domain. Girl Talk in the area of music has done the same thing with fair use in remixing over 300 samples into their last album, something that you could never clear, and said, hey, this is fair use, I'm going to use it. As some of you were aware, Brewster Kahle came here to the iSchool last year, University of Washington's iSchool, and talked about what it would take to put everything up online. And at the end of that conversation, we really saw that a digital library of Alexandria, the only thing standing in the way is copyright. Public Knowledge is another organization that's looking at this from a legislative perspective. They're working on things like digital rights management, the orphaned works issue, and other ways such as net neutrality in order to get information out to people. Also, on a side note, March 25th, there's going to be a town hall meeting here in Seattle with the FTC over digital rights management. The next thing I'd like to direct you towards is the Legal Education Commons, which is a project to take textbooks, put them up in line under a Creative Commons format and allow people to remix those. This project has been supported by several different law professors and is also supported by freeculture.org, which is a student organization on the grassroots level that works to try to bring these projects into schools. At this point, we've made it all the way through all of the stuff that you need to know. I want to point out that the DVD that we gave you has significant resources, including all of the links you're going to see on the next 3 slides, some of the cases that I've talked about here, and it also, all of this information will be up on my website, hopefully also on the National Lawyers Guild website to be downloaded, used in other ways. I also think that in doing a Creative Commons presentation, it's important to let people know ways that they can get involved. So first, see what's going on in the community. Second, contribute to the commons. Use these licenses, use fair use, create parody, create transformative works, and even create educational works. Become a local activist. The last thing here is the accreditation of the other individuals who contributed to this slide presentation. Thank you for your time. I look forward to talking to you.